All right, welcome everyone. My name is Casey Given. I am the Executive Director of Young Voices. We are very pleased today to host Bob Levy to talk about Towards a Better Constitution. Basically, we've had a number of very interesting Supreme Court rulings recently, and he is going to outline kind of what we think libertarian view approach towards constitutionalism will be, and maybe discuss some of the implications of these hearings. This is a regular meeting we hold called the Young Voices Forum, where we'd like to invite and hear many different thought leaders from the libertarian movement to speak before our program participants and partners and donors. So I'm very glad you could all be here today. We're also recording this for posterity to pass along to other folks as well. Just a few housekeeping rules. If you could please keep yourself muted unless you're speaking. We will have time for questions about 35 minutes or so afterwards. So please, while Bob's talking, and you have any questions, feel free to write them down for speaking later on. You can either put them in the chat box and I will read them out loud once it comes to Q&A, or if you would like, you can also read it out loud once I call upon you in the question and answer session. So we are very excited to have Bob here with us. Robert A. Levy is chairman of the board of directors at the Cato Institute and gives his name to the Robert A. Levy Center for Constitutional Studies. He joined Cato as a senior fellow in constitutional studies in 1997 after 25 years in business. Levy received his PhD in business from American University in 1966. That year, he founded CDA Investment Technologies, a major provider of investment information and software. Levy served as the CEO until 1991. He then attended George Mason School of Law, where he was chief articles editor of the Law Review and class valedictorian. Levy received his JD in 1994. The next 2 years, he clerked for Judge Royce C. Lambert of the U.S. District Court in Washington, D.C., and for Judge Douglas H. Ginsburg on the U.S. Court of Appeals for the D.C. Circuit. From 1997 until 2004, Levy was an adjunct professor of law at Georgetown University. His writing has appeared in the New York Times, Wall Street Journal, USA Today, Washington Post, National Review, and many other publications. Levy has also discussed public policy on national radio and TV programs, including ABC's Nightline, Fox's The O'Reilly Factor, PBS's NewsHour, and NBC's Today Show. His latest book is The Dirty Dozen: How 12 Supreme Court Cases Radically Expanded Government and Eroded Freedom. Levy started as co-counsel in the District of Columbia versus Heller, the successful Supreme Court challenge to Washington, D.C.'s gun ban. Bob, we are so happy to have you. Thank you for joining us.
It's great to be with you. My topic for today is Toward a Better Constitution. So I'm going to discuss how the U.S. Constitution ought to be interpreted, and I'll argue that the Supreme Court has occasionally subverted the original design, and I'm going to recommend a few steps to restore constitutional government. Before I do that, I want to set the stage with some comments on liberals and conservatives and how their views of the Constitution and public policy differ from the libertarian views embraced by me and my colleagues at the Cato Institute. So when I speak about libertarianism, I'm not referring to the Libertarian political party, but to libertarianism as a political philosophy devoted to free markets, private property, individual liberty, and strictly limited government. As Cato, as you may know, we don't endorse candidates or parties, and we're critical of both Democrats and Republicans, but we do have a consistent, I'd call it minimalist view of the proper role of government. Conservatives will agree with us on some issues. They tend to be things like the fiscal issues, taxes, spending, deregulation. Liberals agree with us on other issues, things like marriage equality, drug legalization, liberalized immigration, and civil liberties. So an obvious question is whether that means libertarians are philosophically inconsistent. No, in fact, it's just the opposite. It's conservatives and liberals who are inconsistent. Conservatives want less government control of the economy and more government on social issues. And the liberals are just the opposite. They want more government control of the economy and less government in the social sphere. Libertarians consistently want small government across the board, a government that stays out of our wallets and out of our bedrooms and out of foreign entanglements unless our vital interests are at stake. So here's the constitutional framework for all of that. The structure of our federal system is, I think, best captured by the final two provisions of the Bill of Rights, 9th and 10th Amendments. The 10th Amendment tells us the national government can only exercise the powers that are enumerated in the Constitution, like the power to coin money and establish post offices. The powers that are not delegated, not enumerated, are reserved to the states or, depending on the provisions of state law, directly to the people. Conservatives and libertarians generally agree on that tightly constrained view of the federal government, but there are a couple of key exceptions. The first of which is a lot of conservatives, but not libertarians, are willing to federalize, and by that I mean assign responsibility to the federal government, a significant amount of both criminal law and civil law. If you want an example in the criminal area, a feckless war on drugs for which there is no constitutional authority. If you look through the Constitution, you'll find reference to very, very few crimes like counterfeiting, treason, and piracy. But beyond that, criminal law is generally left up to the states, not the federal government. If you want an example in the civil area, listen to the conservative outcry for medical malpractice reform. Now, frankly, I agree that we're in need of medical malpractice reform, but the threshold question for a libertarian is, where is that constitutionally authorized? And if you ask conservatives, they'll tell you it's a regulation of interstate commerce. That's sort of a catch-all for just about everything. If you know anything about medical malpractice, you know that typically it's a patient that lives in a particular state that's suing a doctor that lives in the same state for an injury that occurred in that same state where both of them live. So it's questionable as to how that morphs into a regulation of interstate commerce. Libertarians invoke a different principle, and that is, no matter how worthwhile the goal is, no matter how sure Congress is that it's identified a really big problem, and no matter how sure Congress says that it knows how to fix the problem, if there's no constitutional authority to pursue that, then the federal government should step aside, leave the matter up to the states, or better yet, leave it up to private parties. Today, however, the federal government immerses itself in matters ranging from our public schools to hurricane relief, our retirement system, our welfare system, medical care, family planning, housing, even aid to the arts, none of which can be found among Congress's enumerated powers. You know, take a look through the Constitution, see if you can find anything that even resembles federal aid to the arts. There's a second difference between conservatives and libertarians, and that is that conservatives are far more willing to concentrate power in the executive branch. Libertarians remind their conservative friends that too much unchecked authority in the hands of the executive branch threatens the notion of separation of powers, which has been a cornerstone of our Constitution for 233 years. So the administration, the executive administration, I don't just mean Biden, but I mean Trump and Obama and George W. Those administrations may not by themselves set the rules, because setting the rules is a legislative function, not executive. And while the administration may prosecute infractions, it may not determine guilt or innocence, and it may not review whether or not its own activities, that is the executive branch's activities, have comported with the Constitution, because that's not an executive function, it's a judicial function. So that's the powers of government perspective, grounded on the 10th Amendment and the separation of powers doctrine. Now, I also mentioned the 9th Amendment. The 9th Amendment, as you probably know, addresses rights, not powers. And specifically, the 9th Amendment provides that the enumeration of the Constitution of certain rights should not be read as denying that there are other rights that also exist. Rights that we possessed before the government was formed, even before the Constitution was written. So that safeguard imposes another powerful discipline on federal behavior, because what it means is that even if the federal government exercises its legitimate powers in accordance with the 10th Amendment, that is, the powers that are enumerated, even if the federal government obeys the 10th Amendment, the federal government cannot do that in a manner that violates their rights. And in determining which rights can't be violated, the 9th Amendment instructs that we look both to those that are expressly enumerated, like free speech, and to those that are unenumerated, like, for example, the right to travel, or the right to gamble, or for that matter, the right to smoke marijuana. So note that the presumptions underlying the 9th and 10th Amendment, they're exactly opposite one another. And if you understand that, you understand the structure of the Constitution. The 10th Amendment says if the power isn't there, the feds don't have it. The 9th Amendment is just the reverse. Merely because the right isn't there, that doesn't mean that we individuals don't have the right. We have a broad range of rights that we possessed pre-government and pre-constitution. So if you wanted to identify a single constitutional provision that distinguishes libertarians from conservatives, it would be the 9th Amendment. The conservatives treat the 9th Amendment as an ink blot, using former Judge Robert Bork's memorable word. He asserted that the 9th Amendment should be ignored because nobody knows what it means. It's as if somebody spilled ink on the portion of the 9th Amendment that would have identified our unenumerated rights. To the contrary, libertarians treat the 9th Amendment as if it, like every other provision of the Constitution, it means something. And libertarians argue that it refers to our natural rights, the rights that we had by nature, pre-government, and that we still retain. And if you look at the 9th Amendment, the text, it says rights retained by the people. So you can't retain what you didn't already have. What kind of rights are covered by the 9th Amendment? In short, they're all of the so-called negative rights. Sounds like a pejorative term, but it's not meant to be. Negative right is just a right that when you exercise it, it doesn't injure anyone. It doesn't impose obligations on anyone else, except the obligation of leave me alone. Avoid the use of fraud or force against me. So the 9th Amendment does not have anything to do with positive rights, which, when they're exercised, do require others to act in a particular manner. So let me see if I can flush that out a bit. The right to pursue happiness is a negative right because it imposes no affirmative obligation on anyone else. I can pursue happiness. I don't need your help. Just leave me alone. By contrast, suppose I had a right to happiness, not the pursuit of happiness, but to be happy, the attainment of happiness. That might require you to act on my behalf, because at a minimum, you couldn't do anything that would make me unhappy. And if you did, I could go to court and force you to stop. So, the positive rights that we most often hear about aren't broad abstractions like the right to happiness, but they are subsets of the right to happiness, like, for example, the right to welfare, the minimum wage, the right to housing, education, medical care, health care. If I have an enforceable right to housing, and bear in mind, when I say I have a right, it presupposes that I have a remedy if the right's violated. So if you have a right, but you can't do anything about it, then it's as if you didn't have the right at all. So if I have an enforceable right to happiness, and somebody, maybe one of you, has the obligation to provide me with a house, or the way it usually works, to pay sufficient taxes so that the government can provide me with a house. These kinds of positive rights, like the right to housing, they are integral to the liberal position on the proper role of government. Liberals embrace big government. Why? Because they embrace positive rights, and positive rights require coercion. Well, why do they do so? Because occasionally people who are told to provide housing for other people would prefer to keep their money to provide housing for their own families or for themselves. So what do we do when they resist? We have government force them to pay for someone else's housing. Again, typically we do that through the tax system. In fact, the government is the only entity in our system that can lawfully use force against its citizens. Now, paradoxically, we now hear from liberals that big government can't be trusted, at least not in this post 9/11 environment that always requires a trade-off between things like national security and civil liberties. But you wonder, where does the left that distrusts big government in certain areas, where does the left stand on big government control over things like our retirement system, our welfare system, public schools, and the private economy? Why hasn't the left's healthy distrust of big government in the civil liberties area extended to things like supporting privatized Social Security or school choice, or the elimination of regulations that seem to control everything from the size of a naval launch to the shape of office furniture? Why can't liberals see past two government agencies, namely the Defense Department and the Justice Department, when they express their concern about excessive government? All the other agencies, according to liberals, can grow bigger and bigger, and the liberals approve, but not defense and not justice. And oddly enough, those two agencies are the very ones that are charged with protecting us against domestic and foreign predators, which is an indisputably legitimate function of government. You know, imagine if Congress were to delegate to the Justice Department the power to enact regulations over this trade-off between national security and civil liberties. And it said to the Justice Department, here's your guidance, keep us safe from the terrorists. Well, people on the left would be apoplectic, and they'd have every right to be. But why? Because the Justice Department isn't supposed to be enacting laws. That's the job of Congress. But when the same Congress delegates to the Environmental Protection Agency the power to enact regulations mandating clean air, and it gives the EPA no more guidance and keep us safe from the pollutants, the left applauds enthusiastically. So could it be that pollutants are a greater threat than terrorists? Not likely. What's more likely is that the left has a selective indignation about government, and that reflects an inconsistency in the liberal mindset, just as there is an inconsistency among conservatives on the proper role of government. And of course, that's the foundational question. What is the proper role of government? And what I'm suggesting to you is that in examining that question, the Constitution can be viewed through these two prisms, the powers of government prism, which is the 10th Amendment, and the rights of individuals prism, which is the 9th Amendment. Libertarians, in a nutshell, view the powers of government very narrowly and the rights of individuals very broadly. And we argue that that was precisely the vision of the framers. Okay, now let me discuss various theories of constitutional interpretation and which one is correct. And I'll do this in question and answer form, except I'm going to be asking the questions and then I'll provide the answers later. We can have time for questions from you folks. So question number one, Chief Justice John Roberts claims that the court's not political. Was he correct when he said we do not have Obama judges or Trump judges? Well, you know, Roberts obviously knows that presidents get to nominate their choices. The choices are likely going to have the same political philosophy as the president's. What Roberts meant by that is that each judge should have a primary allegiance and a responsibility to the law and to the Constitution as he or she perceives it and not an allegiance to the president's policy preferences. So Supreme Court justices appointed by liberals are surely going to disagree with justices appointed by conservatives. But that's because they have a different theory of constitutional interpretation. It's not because their actions are necessarily directed at satisfying the president or his electoral base. So the key here is judicial independence. And I think in that sense, Roberts was mostly right. Interestingly, since 2000, about half of the Supreme Court's cases have been 9-zip or 8-1 or so. This latest year, on the final day of the 2022 term, the court upheld Biden's repeal of Trump's remain in Mexico policy. That's a conservative court going against Trump. The court also declined to review New York's vaccine mandate for healthcare workers, even though the mandate had no religious exemption that you would expect a conservative court to go for. And a few days earlier, the court had disappointed the law and order branch of the conservatives when it ruled 9-zip that doctors could be convicted for opioid abuse, but only if they believed that they were overprescribing. So those decisions, I think, reflected a consistent application of conservative judicial philosophy, not conservative politics. Question 2, what judicial philosophy should we be looking for in a justice? Well, there are two most prominent theories. They are textualism, which is favored by conservatives, and the so-called living constitution, favored by liberals. Unfortunately, the media consistently misinform the public about conservative judicial philosophy. So you'll hear over and over again that the conservatives believe in original intent. Now, strictly speaking, that is not textualism. Scalia was, Clarence Thomas is a textualist. They rely less on the original intent of the framers and more on the original meaning of the words in the text. A judge should attach primary importance to the words actually in the Constitution. And Scalia put it this way, and this is a quote: "It's the law that governs, not the intent of the lawgiver." So in textualists, they interpret the Constitution in accordance with its meaning when the underlying provisions were originally ratified, not the meaning that derives from a modern reading of the text. But original meaning is not the same. It's not synonymous with original intent. Meaning focuses on the words of the document. Intent focuses on the values and the objectives of the drafters and the ratifiers. So here's the problem. If you wanted to apply original intent, we don't know which drafters or ratifiers are authoritative. How are there differing views to be resolved? Hamilton and Madison often disagreed over key provisions. And in fact, without good records of the Constitutional Convention, we can't even determine what their original intent was. Question 3, conservatives are also labeled by the media as strict constructionists. Is strict construction the same as textualism? No, it's not. And again, Scalia explained the difference, I think, succinctly. He said, quote, "I'm not a strict constructionist, and no one ought to be. A text should not be construed strictly, and it should not be construed leniently. It should be construed reasonable to contain all that it fairly means." So if you wanted to interpret a constitution written in 1789, the best tool would be a contemporaneous dictionary, one that was available in 1789. And that wouldn't define the words strictly, wouldn't define the words loosely. It would define the words in accordance with their actual meaning at the time. And by the way, textualism does not mean that the Constitution is frozen in time at 1789. There's no textualist that I know of who believes, for example, that free speech protections don't extend to the internet, even though the framers could never have conceived of an internet. So it's okay, according to textualists, to examine the trajectory of the words and apply those words to changing circumstances. What's not permissible is to treat the words as if they mean something different than they clearly meant at the time of ratification. Question 4, what about the liberal view of the living Constitution? Liberals want the Constitution to be interpreted in light of new circumstances, sort of a malleable document that can be adapted to current societal demands. Justice Breyer was probably the foremost proponent of the so-called living Constitution, and here's how he described it. Quote, the Constitution has to have structural flexibility sufficient to adapt substantive laws and institutions to rapidly changing social, economic, and technological conditions. President Obama believed that as well. And he told us, again, his quote, our courts should stand up for social and economic justice. So Obama wanted justices who have, again, a quote, the empathy to recognize what it's like to be a young teenage mom or to be gay or poor or black. So that may sound perfectly reasonable. And I think the textualist response will be twofold. First, although empathy is certainly a desirable characteristic for a judge, it's not a basis for determining the Constitution's meaning. It can't replace the words that are actually in the document. And second, the framers provide an amendment process for structural flexibility. So if the Constitution needs to be updated, it should be accomplished by amendment, not by pretending that the written document doesn't exist or doesn't mean what it says it means. And in fact, what's the purpose of a written document if you activate it? It's just a piece of paper. In assessing whether a judge is deciding cases in accordance with his or her interpretation of the Constitution or in accordance with his or her political views, I think you should ask yourself this question. Was the decision in the case based on the judge's philosophy of the law, or was his philosophy of the law tailored to his preferred outcome in the case? And the best way to resolve that question is to examine over time the consistency of a judge's jurisprudence. So for conservative judges, we should ask, have they applied textualism uniformly, regardless of the underlying public policy question? For liberal judges, however, I think the answer to that question is self-evident, because a theory that treats the Constitution as a living, elastic document has no doctrinal foundation. In fact, the essence of a malleable Constitution is its variability, its unpredictable implementation. Okay, that's the background, and now let's turn to the Constitution itself and discuss those provisions that, from my perspective, and I think most libertarians, these provisions haven't panned out. It's been 231 years since the Constitution and the Bill of Rights was ratified. It's been amended over that time only 17 times. Some countries had nearly that many constitutions, much less amendments. So why have there been so few changes? Even though the framers could never have imagined what our 21st century world would look like. And I think there are three key reasons for that. Two of them are good, one's not so good. The first good reason that there have been only 17 amendments in more than 200 years is the Constitution is incredibly well crafted. And it was written by brilliant legal minds who had a vision of liberty that's every bit as relevant today as it was in 1789. And the second reason is that Article 5 of the Constitution which governs the amendment process, sets up several difficult hurdles. Essentially, 2/3 of both houses, the House and the Senate, have to propose amendments, and they have to be ratified by 3/4 of the states. And not surprisingly, that hasn't happened very often. And the result is that we have a very stable constitutional framework. So I mentioned the bad reason, and the bad reason, in my view, is that the Supreme Court has accomplished through the back door what the Congress and the states could not accomplish through the amendment process. And that's why my colleagues at Cato, when we were asked about how the framers could have improved the document, we sort of reply tongue in cheek that they should have left it the way it is, but appended 5 words at the end. And the 5 words would be, "and we really mean it." So, put differently, the main problem is not the document itself, but it's rather the misinterpretation of several of its key provisions. And if I were entrusted with rewriting the Constitution, I would clarify 3 provisions in particular. The taxing power, the Commerce Clause, and the so-called non-delegation doctrine. So let's take a quick look at each of those. First, the taxing power, sometimes known as the General Welfare Clause. It says that Congress shall have the power to lay and collect taxes to provide for the general welfare of the United States. And the meaning of that was tested back in the New Deal in 1937. A Supreme Court case called Halvering versus Davis. The issue there was the constitutionality of the Social Security system. So, you have to think like a judge. It's not whether Social Security is a good idea. It's not whether it's actuarially sound. The question is, where in the Constitution is the federal government authorized to create such a system? And proponents pointed to this General Welfare Clause. That clause triggered a major clash between Hamilton and Madison. Hamilton's view was that the power to tax to provide for the general welfare is an extra power over and above Congress's other enumerated powers. And Madison's view said that that can't be, because everything could be characterized as providing for the general welfare. And accordingly, Hamilton's idea would sort of eviscerate the whole notion of limited government powers. And Madison even went a step further. He said, not only is that clause not an extra power of Congress, it's a restriction on Congress's other powers. What it means, according to Madison, is that in carrying out its enumerated powers, Congress has to jump through one more hoop. It can't do that in a manner that violates the general welfare. It has to promote the general welfare and not the welfare of what Madison called factions and what we today call the special interests. So the Supreme Court weighed in this 1937 case and basically said, Hamilton wins and Madison loses. And in other words, the federal government could compel everybody to provide for their own retirement through the Social Security system. And that opened the floodgates through which we have this redistributive state pouring through, taking money from some people and giving it to others without any meaningful constitutional constraints. So what's the fix? I think we need a constitutional amendment stating that the taxing power does not supplement Congress's enumerated authority, but rather it directs that federal taxation can fund only the powers that are both enumerated and promote the general welfare. All right, next is the Commerce Clause, the power to regulate commerce among the several states. So can that power be extended to activities that are not interstate and in fact are not even commerce? Sounds like a no-brainer, but the answer, according to the Supreme Court, is yes, it can. That's what happened in the 1942 case that you probably have heard of, Worker v. Filburn. Filburn grew wheat on his own farm within a single state. He didn't buy it, he grew it. And he didn't sell it, he ate it, or he gave it to his farm animals. And Roosevelt, FDR came in during the Depression, said, the price of agricultural products is too low, so we need to curtail your production, Mr. Filburn, so that would reduce the supply and increase the price. Filburn says, under what authority? Roosevelt says, the power to regulate interstate commerce. Filburn replies, look, my farm isn't interstate, it's all within one state. And by the way, I'm not engaged in any commerce, I'm just growing this stuff and eating it. The Supreme Court weighs in, basically says, Filburn, you just don't get it. If you didn't grow the wheat, you would have been buying the wheat. And if you didn't eat it all, you would have had some left over to sell. So by growing and eating, rather than buying and selling, you've obviously had an effect on the supply and demand for wheat. And when we consider other farmers who are doing the same thing, there could well be an aggregate impact on interstate commerce. So that opened, a second set of floodgates, and we get not the redistributive state, but the regulatory state, ready to regulate anything and everything under the rubric of the Commerce Clause. So Wicker v. Filburn paved the way for the Obama administration's claim that Congress can even punish the failure to purchase a product, namely health insurance. And that claim was unprecedented under current law. As you may know, it's illegal to buy health insurance across state lines. So there was no interstate market to be regulated. And furthermore, if Congress could mandate the purchase of health insurance, how about the purchase of exercise equipment or the purchase of healthy foods? This individual mandate would have extended the dominion of the federal government to virtually all manner of human conduct, including non-conduct. That is, the decision not to engage in conduct. Happily, the Supreme Court finally said enough is enough. And in the Obamacare case, NFIB versus Sebelius, the court said the government may not compel us to engage in commerce so that then it can step up and regulate us because we're engaged in commerce. That would be what the court called bootstrapping. So non-acts, that is the refusal to buy health insurance, could not be regulated under the Commerce Clause. And of course, as you may recall, the court then went ahead and said, by the way, it's okay to regulate it under the taxing power, so that Obamacare was declared to be constitutional, even though it was not constitutional to do this under the Commerce power. So here's where we stand regarding the Commerce Clause. Originally, it authorized the federal government to regulate interstate commerce. But under Wicker v. Filburn, that authorization mushroomed to cover acts that didn't involve commerce and weren't even interstate, as long as the acts had a substantial aggregate effect on interstate commerce. And 53 years later, after Wicker v. Filburn, in a 1995 case called U.S. versus Lopez, the court drew a line in the sand. And Mr. Lopez had been indicted by the feds for possessing a gun within 1,000 feet of a school. And the feds said, this is authorized under the Commerce Clause. But, said the court, look, possession of a gun is not an economic act. The Commerce Clause covers only economic acts. What are they? Well, things like mining or manufacturing or agriculture, as in Wicker v. Filburn, or distributing goods and services, or consuming, eating, as in Wicker v. Filburn. And of course, buying and selling, which is the ordinary definition of commerce. So not possessing. Despite these constraints imposed by Lopez, the gun possession clause, and the Obamacare case, the Commerce Clause has sort of become an all-purpose federal regulatory bludgeon. What's the appropriate remedy? We should have a constitutional amendment that expressly restricts federal regulation to real commerce, and that is trade, buying and selling. And it has to be across state lines, that is actually interstate. 1/3 a third constitutional amendment that I'd like to recommend, and that is another to slow the growth of this Leviathan government. This would rein in the administrative state. And by that, I mean the exercise of legislative power by executive departments and independent regulatory agencies. In Article 1, Section 1, the very first sentence in the Constitution after the preamble, it says all legislative power is vested in Congress. Now, why did they say that? Because the framers were really smart guys, and they knew that if Congress passes an oppressive law, the voters can respond by electing somebody else. Here's the problem. Suppose the law is murky and Congress decides to let one of roughly 320 regulatory agencies that we have now flesh out the oppressive details of the law. The courts, they don't do much about it. And the voters, they can't do much about it because these agencies and these cabinet departments are run by unelected bureaucrats that are not necessarily responsive to the political process. Congress's powers are not inherent. They are delegated to Congress by the people through the Constitution. Accordingly, Congress cannot redelegate those powers unless the people, again, through the Constitution, consent. That's called the non-delegation principle. And just as important, the doctrine of separation of powers does not permit combining legislative, executive, and judicial functions in one entity. That many of these 300 plus agencies have all three powers combined. So, the argument is Congress, it's very complicated. So we need these agencies. Well, if Congress needs technical assistance, it certainly can consult its own internal staff or universities or professional associations or think tanks like the Cato Institute. And naturally, it can consult these agencies that are responsible for implementing law. But Congress itself should have to review the recommendations of these agencies and sign on before these recommendations become effective. Under our system, Congress needs a consensus to pass laws. So who are the 535 legislators that an administrative agency has to convince? How do we know that opposing views were adequately aired? And where's the record of the agency's deliberations? What factors were considered and rejected? And most important, what do the voters and the taxpayers do if the agency gets it wrong? What have the courts said about all of this? Well, the courts have said, look, we know Congress is supposed to enact legislation and not pass the buck, but governing is complicated. So we're going to make an exception. Delegation of legislative power to these agencies and executive departments is okay, as long as Congress lays down an intelligible principle so the agencies know how to fill in the gaps. What precisely is meant by an intelligible principle? Nobody seems to know, least of all the taxpayers who have to foot the bill. So as a result, Washington, D.C.'s alphabet agencies are now operating overtime. We have Health and Human Services regulating healthcare, the FCC trying to control the internet, and the Consumer Financial Protection Bureau making lots of mischief on the Dodd-Frank Act. And if you want to grasp how big a problem that is, just consider that these federal agencies now dwarf Congress when it comes to making rules that control what Americans can do. The rules are printed. They're codified, the Code of Federal Regulations. That publication is more than 200 bound volumes, about 6 times as large as the US Code, which contains all the laws passed by Congress. In the final year of the Obama administration, Congress enacted 2,966 pages of laws. Sounds like a lot. The same year, federal agencies turned out 32 times as much, a total of 97,000 pages of regulations. So to correct this delegation problem, I would suggest an amendment that would require Congress to vote on all regulations with an annual impact exceeding some dollar threshold, let's say $100 million. The court's decision this past term in West Virginia versus EPA comes close to that. It requires a clear delegation from Congress on all major questions. So to recap, my sense is that amendments reaffirming the original meaning of the non-delegation doctrine, along with the taxing power and the Commerce Clause, would go a long way toward curbing our runaway federal government. Let me summarize very briefly. Libertarianism is a political philosophy that's grounded on these propositions. Adult individuals have the right and the responsibility to decide important matters about their own lives, but they can't infringe on the equal rights of anyone else. The role of government is to secure those rights, that is to protect innocent individuals from harmful acts by others and by government. The role of the Constitution is to protect innocent individuals from government's harmful acts. So that's my story. I'm sticking to it, and I'm happy to answer any questions that you might have about the material that I've covered or any related constitutional issues.
Thank you so much, Bob. We have two excellent questions already in the chat that I will read out loud. I think for the sake of time, since we have about 12 minutes left, if you have a question, if you could please type it out in the chat box, that would be great. So our first question comes from Cody. He says, thank you for presenting today, Mr. Levy. Do you believe that all or parts of the Bill of Rights applies against the states? If so, is that application via the Due Process Clause of the 14th Amendment, the Privileges or Immunities Clause of the 14th Amendment, the Supremacy Clause, or some other provision?
So when the Constitution was originally ratified in 1789, the 10th Amendment said that all the powers that are not delegated, enumerated and delegated to the federal government belong to the states. So that was the division of power for the first 70 years or so. We found out during that period of time that the states can be just as tyrannical as the federal government, slavery being the obvious case in point. So we fought a civil war. And after the Civil War, we had a number of constitutional amendments, probably the most important, at least the one most related to the question, is the 14th Amendment. And the 14th Amendment gave the federal government a brand new set of powers. It said that if the states violate any rights that originally applied only with respect to the federal government, then the federal government would step in and stop that. Bear in mind that the original Constitution said, for example, the First Amendment, Congress shall make no law impairing free speech. Didn't say anything about the states. So the states under the original Constitution, they could have passed a law that said you can't criticize the governor. That may have violated the state constitution. It would not have violated the federal constitution, because the federal constitution didn't apply to those states. So the 14th Amendment changed that. And it said, if the states violate any of the constitutionally guaranteed rights, then the feds could step in. Now, of course, that was the principle. It had to be codified, and it didn't happen all in one fell swoop. It happened amendment by amendment over a long period of time. So there would be a case involving free speech, and then another case involving religious freedom, and another one involving searches and seizures, and it went on and on and on. Almost all of the Bill of Rights have now been, the technical term is incorporated, meaning applied to the states. So the states cannot violate those provisions. Most recently, by the way, the incorporation of the Second Amendment didn't occur until the Heller case, until the McDonald case in 2010. So this process really unfolded over quite a lengthy period of time. What provision of the 14th Amendment was used to do the incorporation? It was the Due Process Clause. Now, a number of people have questioned that, most particularly Clarence Thomas, and he has said, among other things, look, I look through the Constitution, I can't find anything that says the due substance clause. It says process. Process is not substance. Process refers to procedure. It refers to the notice of a wrongdoing and an opportunity to be heard in a hearing, etc. It's not the substantive content of the law, it's process. Thomas would say, and I certainly would agree, and I think a lot of libertarians would agree, that the most appropriate clause in the 14th Amendment, which should have been used to incorporate these provisions, was not the due process clause, but the privileges or immunity clause, which unfortunately was virtually wiped out of the Constitution in the slaughterhouse cases. So there does seem to be some movement, at least by Thomas, and he wrote this much in his concurring opinion in the abortion case, some movement to revisit some of these cases that relied on the due process clause and try to establish, revitalize the privileges or immunities clause.
Fabulous. Our next question comes from Eli. He says, thank you for your time today, Mr. Levy. Does Justice Ketanji Brown Jackson's background as a defense attorney rather than a prosecutor make you optimistic that SCOTUS is making a more libertarian turn on criminal justice reform?
Yes. Her background is, she's the first person to come from the defense bar. By the way, her background is quite impressive. You know, she was a high school debate champ, Harvard Law, a law review editor. She was a federal judge for 9 years. She spent some of those years, 1 year on the DC circuit, which is the second most important court in the land. She was supported by some Republicans, not very many, but Lindsey Graham, I think Lisa Murkowski, and Susan Collins. She served on the Sentencing Commission. She was a public defender. The court has always had a prosecutorial tilt, but because she is the first person to come from the defense area, I think that's a very hopeful thing. She was supported by lots of liberal groups, but she also ruled that there was no absolute immunity for White House counsel Don McCann. She said presidents are not kings. That's a healthy view. She blocked Trump from doing some of these deportations that he was doing. On the other hand, she allowed his wall to go forward over protests by some environmental groups. So it indicates that she has some objectivity and some respect for the rule of law. She supported some of the Gitmo detainees, but she said that she did so in her capacity as a public defender, not necessarily what she would have ruled had she been a judge. So the answer to the question is yes, I think her background does give us some hope that there will be more respectful, some movement toward criminal justice reform.
Great. I'm going to take moderator's privilege and ask a question of my own. It seems like there is a perception among the left, increasingly so, that the court is being politicized or conservative, and more calls, at least on the political class, to openly ignore or or work around the Supreme Court's rulings. I think it's interesting, in particular, the recent case of New York State's concealed gun carry law being overturned. The state almost immediately passed a new law that many are saying is unconstitutional again. Do you think that more instances like this might happen because of some perception that the court is increasingly political?
So the case you're referring to was New York State Rifle and Pistol versus Bruin. And this was a challenge to a pretty old New York law that required a special need for concealed carry. Two plaintiffs got permits for target practice and hunting, but not for self-defense. Thomas wrote the opinion for the court, 6-3. It said basically that Americans have a right to carry a handgun outside the home for self-defense without proving a special need. Bear in mind that the original individual right case, the Heller case, decided back in 2008, was limited to carrying a handgun in the home for self-defense, didn't relate to carrying a gun outside. So the new decision, the Thomas opinion, overturns this New York law and puts at risk similar laws in several different states, most of the liberal states like DC, California, New Jersey, Maryland, Hawaii, Massachusetts. Previously, the court had followed a two-step approach on these Second Amendment cases. Step one was examine whether the regulation was consistent with the text, history, and tradition of gun regulation and the Constitution. And step two, assuming it was, then ask the judges to make some empirical judgment, policy judgment really, about the costs and benefits of firearms restrictions. So the new case, the Bruin case, said, look, we're not going to do this two-step approach. We're going to do just one step. And we concluded that New York did not meet its burden because these laws were not consistent with the tradition of gun regulation over our history. The net result of which is that shell issue laws that have objective requirements like age, for example, training, mental health, no criminal record, they may still be valid, but may issue laws where discretion is in the hand of bureaucrats are probably going to be unconstitutional. So your question was whether I think there's going to be lots of attempts to circumvent this. Now, the answer is yes. I don't believe that this two-step approach is workable. How the right can be defined narrowly or broadly makes all the difference, and in effect dictates the outcome. Let me give you what I think is a pretty good example of that. Race v. Gonzalez, we had a sick person who claimed a fundamental right to use medical marijuana in California, where it was legal, and she had a doctor's order. And the Court of Appeals characterized the right as the use of cannabis for medical purposes. So she lost. Why? Because medical marijuana is not deeply rooted in our history and traditions. So suppose the court had adopted Raish's broader characterization of the right, which was the liberty to pursue her own life in a less painful fashion, and to treat her body the way that she preferred. She would have won, but the court took the narrow definition. Then comes along Lawrence v. Texas. The Supreme Court overturned a state regulation, a Texas regulation, and criminalized consensual sodomy. So Texas loses the case. Why? Because the court characterizes the regulations as barring a relationship within the liberty of persons to choose, a very broad definition of the right. Suppose the court had said, oh, this is about gay sex. Then that right would not have been deemed to be deeply rooted, in our tradition and history. So which of these characterizations is correct? They're both correct. Race is trying to live with less pain. She's also using medical marijuana. Lawrence is pursuing this private, consensual, no harm relationship. He's also engaged in homosexual sodomy. So the court, you can rule how it wants, just based simply on whether it describes the right broadly or narrowly. And that's the folly, I think, of this two-part test and limiting it to just a consideration of whether it's part of a historical text and history. I think the rule ought to be that all rights, if regulated, the regulations have to be rigorously protected by the courts. And because gun rights are fundamental, and because they're expressly secured by the Second Amendment, and the court has so ruled, then any regulation has to be strictly scrutinized. And that means the burden is on the government. It's not on the would-be gun possessor and user. The burden is on the government to show that there's a compelling need for regulation. Maybe public safety would be that compelling need, but then government has to go 2 more steps. They have to show that the regulation would be efficacious, and secondly, that the regulation is no part of it. Has to be. It's narrowly tailored to serve the public safety need.
Fabulous. Thank you so much. Well, it's past 1 now, so that's all the time we have for now. I want to thank you so much again, Bob, for your time. And thank you everyone for your fascinating questions. I'll email out a recording to this afterwards. Thank you so much for joining the Young Voices Forum, everyone. We hope to have more events like this. And I hope you all have a wonderful week. Thank you. Cheers.